not, but we'll do that next time. Huh?
Say that again.
I said we'll need to get Carolyn's information to add to this screen and pull things down when people aren't here, and just we need a stock slide that we can delete and add people's names to it on one. So no big deal.
All right.
I'm ready. Let's let them in. Let's roll.
All right. I will open the floodgates. All right. Good morning, everyone. Thank you all for joining us today. Let's see. People are still trickling in, so we'll give it just a minute, but Jim's got some interesting stuff for you. And yeah, hope you all had a good weekend.
Morning, everybody. This is not going to be your normal full-fledged discussion where we go into a lot of different things. I'm going to hit on what we need to focus on, let you know what it is that I think you need to be doing, and answering any questions that you have. I did just put in the chat the fact that Tyler is going to also be answering questions if he can in the chat to try to keep up with them. The last few times we've had so many questions in the chat that it's been impossible to even keep up with it. So there are not a lot of slides today. There's a lot of information about where we stand. And then from there, we are just going to answer questions and tell you kind of what I think you should do while we wait for more definitive information, which ironically is almost all going to come out of the Sixth Circuit Court of Appeals. So we're going to give it a couple of more minutes because we had a tremendous number of people who registered that are coming online, and I don't want them to miss it because it is, this is down and dirty, straight to the point on what you need to be worried about with the vaccines. I'm not covering anything else. There are a couple of interesting new tidbits out there if you're a federal contractor, and I'll cover those. I don't have a slide on it, but I'll cover those for you to be aware of if you have federal contract. So we're at 11:03. Allison, you want me to roll or you want me to wait a little bit?
Yeah, I think you're good to roll, and I'll just keep letting them in as they.
All right. Well, then we're going to go ahead and get this going. So you know exactly who I am, and you know about Tyler and Lyle. Lyle is somewhere in Antarctica. He heard that they had 0 COVID-related illnesses, so he decided to go down there and snuggle up with the bears. So he's down there somewhere with a polar bear. Yes, I know they're not there, but it sounded good. All right, so Allison's with us today. We have Carolyn with us too. We don't have everybody, but you know how that rolls. Tyler is definitely with us. He's going to try to hit the questions as they come up in the question and answer. And anything that I can't answer, or that he can't answer or gets too deep, then I'll try to answer those. I will tell you there's so much going on right now. Some of this I'm going to have to tell you, go contact your attorney because it gets really, really, really in the weeds and there's no way to give you general guidance. So here we go. This is a quick hit update. I'm not going to go into a whole lot of other things, but the mask mandates, employer mask mandates, all of them are really, it's up in the air, and we are the epicenter right now for the entire country, not just because of what I gave you last week. So here you go. This is us. The little one on the right-hand side there, he is the kingpin. He keeps everything. I don't mean Tyler, by the way. This guy right here is the only reason why I let Tyler come to the office, you know, so I'm joking. Okay, here we go. There are 3 different mask mandates. If you don't know about them, it's because they didn't apply to you. If you do, if you do know about them, good luck trying to figure out how to navigate this until we get further guidance. So you've heard us talk about OSHA, the ETS. You also had the Safer Federal Workplace Task Force mandate that came out. Those are your federal contractors. And then you also had the CMS, Centers for Medicare and Medicaid Services. The issued a rule. All three of those for Kentucky have been thrown out temporarily on an injunction. I was going to put in here what an injunction means, but I don't really want to get into legal argument and legal discussion. But basically what an injunction means, if it's issued by a court, it means that the court believes that there is a substantial likelihood that the party seeking an injunction will in fact prevail, that there is very little chance of the other side prevailing, in this case, the United States. And then the court does a weighing of, the impact on society and whether it's more influential to set it aside and to stop the enforcement of a statute, or whether it's more important to keep status quo and allow them to enforce it while it's being considered. It is not a final order on everything, but it is an indication from at least one federal judge, if not more, that there are serious problems with these mandates. The irony is this: they didn't need to have all of these court filings and everything else. All they had to do was join our webinar back in January. Yes, if you will go back and you look at the end of January, as soon as the new administration was in place, I had a listing, and I know a lot of you come to all of these. I had a listing of all of these executive orders that were getting just embedded on the first day. And I pointed out to you the one that and this goes all the way back before the election. I told you that the suggestion from one of the candidates that there could be a national mask mandate and a national vaccine mandate goes against our Constitution. The federal government cannot issue mask mandates. The federal government cannot issue vaccine mandates. Well, they tried. This is the outcropping of that. Since January, we've been cautioning you on the ETS cannot really come into play because I cannot fathom a way that they can order this across the board for all employers without any restriction, without running afoul of the state's rights. Well, that's kind of what's happened here. So here we go. First, we have the ETS. You all remember I addressed with you the Fifth Circuit Court of Appeals issued a temporary injunction. Then the Sixth Circuit won the lottery. The Sixth Circuit is Michigan, Kentucky, Ohio, and Tennessee. When it received the lottery, though, it became the nationwide repository of all challenges regarding the ETS. So if you look at their filings, they're getting hundreds of filings every day from all of the interested parties, intervening parties, people who want to weigh in with a amicus brief, as it's called, and several other things that are currently running through the Sixth Circuit. Immediately after the Sixth Circuit was appointed, the United States came out with a motion to set aside the Fifth Circuit temporary injunction. The deadline for response to that is right here, December the 10th. Well, that's later this week, but the ETS will definitely be suspended through at least December the 10th because the Sixth Circuit indicated it would not rule until every stakeholder had an opportunity to respond. The problem is, the issue is, even once the December 10th date comes, you're dealing with, quite literally, hundreds and hundreds of briefs that have been filed. Because if it was in the First Circuit, the Second Circuit, every circuit except it may have been the Ninth, that was the only one that did not weigh in on having a challenge. So you have 13 different circuits that are addressing the issue, all of them with different parties and amicus briefs and friend of the court briefs and different things being filed. It's going to take a long time for a panel to address this. The other thing is there is a motion pending to have this be en banc, the entire Sixth Circuit. So the answer is, if you have more than 100 people and you were governed by this mask mandate, don't hang up on me yet because I still have some updates for you. But right now, enforcement under federal law is suspended. So the stay will stay in place until or unless the Sixth Circuit issues its opinion, and you can be guaranteed that if and when they issue their opinion, it'll be all over the news. We will have an update here, and it'll be a big deal. The Sixth Circuit is the epicenter for the ETS, the Emergency Temporary Standard. So, the other thing that OSHA did in response to the motion, the temporary injunction, was they decided to extend the response deadline because they asked for public comment, but they literally gave you only 30 days from November the 5th until today. They extended that until January 19th. They've already received over 94,000 comments on the emergency temporary standard. A lot of those are because, like I said, they had no underpinning for this. They had no definitions. They had no information. They gave you no support. So a lot of those comments are basically along the lines, and I take credit for it. I think it's all because, you know, everybody was watching my webinars and said, wow, we need to reach out and make comments. So to the 94,000 people on this call, we're a little short of that right now, but, you know, the ETS has its issues, but I want you to be aware, and that's what we're going to talk about on the last slide, that you still need to be doing some legwork, because this will take effect immediately upon, if it gets upheld, it will take effect immediately and you'll have to scramble. So this will end up in front of the Supreme Court. Quite frankly, I'm surprised no one has already requested that the matter be transferred directly to the Supreme Court, which 9 times out of 10, 99 times out of 100, it will be rejected, but I could see someone asking. All right, so the second of the three, the trilogy of mask mandates, is the Medicaid Medicare Services Act. On November 29th, a federal judge in Missouri issued a preliminary injunction, but it only dealt with 10 states. So I thought, you know what, let's not do an update for you. We weren't one of the 10 states. The very next day, a federal judge sitting in Louisiana said, you know what, that's a really good rationale for those 10 states, but all 50 states are impacted. Therefore, I'm going to extend the preliminary injunction that was issued by the Missouri judge, and I'm going to declare that it is nationwide. So the Medicare, Medicaid vaccine mandate from the federal government is in fact precluded as of the 30th. I threw in here this third one simply because it's interesting. Number one, Florida tends to be more conservative. The judge in Florida declined to issue any preliminary injunction at all. So now you have one that says 10 state, you have one that says nationwide, and you have one that says we're not going to enjoin anything. That is an immediate red alert that this is going to end up also in front of the United States Supreme Court. Why? Because these jurisdictions are coming up with different rulings that impact citizens of the United States differently in the different circuits, and that's how you end up with a Supreme Court. So this is literally day by day. It's being handled differently in these different cases. This probably will end up being another lottery case unless there's a way for a party to uniquely suggest that we already have this in the Sixth Circuit. We ought to go ahead and have everything piggybacked. I know that the United States will not agree to that because the Sixth Circuit trends more conservative, and they're hoping for a Ninth Circuit appointment so that they can get this in front of a circuit that they believe they can run things. So chances are you're not going to get a stipulation that the Sixth Circuit addresses this, but for all the hospitals on the phone, for all of the different entities that deal in Medicare, Medicaid, that injunction has been thrown out. The enforcement has been thrown out by the injunction. So this creates a tremendous issue for you as well. The third trilogy, independent contractors working with the federal government. This is interesting because this is only Kentucky, Ohio, and Tennessee. Michigan refused to join Kentucky, Ohio, and Tennessee for political reasons, so the ruling did not address them. Judge Van Tatenhove from the Eastern District of Kentucky, right here in Lexington. Actually, he may have been presiding in Frankfurt at the time that he issued the order. Yep, His order came out of Frankfurt. It's a 29-page order if you want to read it. I've got it. It's really exciting. Actually, from a legal standpoint, it is. He issued his order and said he's going to limit his order to the 3 states that are included, plus 2 sheriff departments in Ohio that joined the states of Kentucky, Ohio, and Tennessee. He issued a broad-based preliminary injunction in those states for all companies that have operations in those states. The important thing is he listed at the outset in the introduction of his order the number of dollars that each one of these states had, whether they were operations in the state or whether they were companies that originated in the state that had operations outside of the state. So that has some bearing on the last thing that we're going to talk about here in just a minute, which is what if we have operations in Kentucky and Michigan? How do we comply with Judge Van Tatenhove that has an order that says you don't have to comply in these 3 states, but you do everywhere else? Well, the judge in this case, the order is very interesting from a legal perspective, and it's very well written. He did a very good job of going through, addressing all of the issues, just like I had raised concerns about all the way through. He addressed those same concerns. He rejected some of the arguments of the plaintiffs because they went too far, but then he found on some of those that the president simply does not have authority granted by Congress to issue an executive order without any underpinning and without the authority of the legislative body. He relied very heavily on the Fifth Circuit Court of Appeals ruling that issued the injunction on the ETS. He said if OSHA can't issue broad-based mandate, then how in the world can the president do this without legislative authority? And the direction that the president tried to rely upon was summarily rejected. The interesting thing, and this is something that I truly hope the Supreme Court addresses, the judge in the Eastern District of Kentucky properly, legitimately, and appropriately, those all mean kind of the same thing. His order said this affects all 50 states. However, the Sixth Circuit Court of Appeals has mandated that injunctions should only be as to those parties that are legitimately before the court and should not go beyond the borders of the parties themselves. Unlike some of the others, you've seen orders over the past several years, whether it was against the previous president or the current president. The Ninth Circuit is famous for this. One judge sitting in San Francisco issues a nationwide blanket injunction and says, president shall not do this. And then it takes the Ninth Circuit setting it aside, or it takes the United States Supreme Court saying, you gotta be kidding me, you can't do this. Well, the Sixth Circuit takes a very circumscribed approach, and someone has to get the different circuits to understand you can't issue nationwide mandates. You must do it on a case-by-case basis. Sixth Circuit says we can't do it. So this order literally says all 50 states are impacted. All 50 states should be a party to this. However, my authority is limited to the parties sitting before me, and therefore Kentucky, Ohio, Tennessee, and the 2 sheriff's departments, you cannot enforce these in those states and in those sheriff departments. This will end up being a nationwide preliminary injunction, in my humble opinion, within the next 3 days, unless or until the Ninth Circuit issues a nationwide rejection of the injunction, which I don't see how they can do. So I suspect you're going to see this turning in just a couple of days. So here's where we stand. In the state of Kentucky, in the state of Tennessee, in the state of Ohio, you have 0 mask mandates right now. 0. Federal mask mandate for federal contractor, it's out. CMS, it's out. ETS, it's out. However, the problem is that these are preliminary injunctions that could be flipped on a moment's notice. The Fifth Circuit, the Eastern District of Kentucky, the Judge Van Tatenhove order could be set aside by the Sixth Circuit. He himself could set it aside. The judge in Missouri that issued the 10-state and Louisiana that issued the 50-state on the medical one, those could be set aside either by the judges, by another judge, or by the Fifth Circuit Court of Appeals or the Eighth Circuit Court of Appeals, depending on whether it's Missouri or Louisiana. So the problem here is this. We are living in a world where day by day the human resources aspect is being impacted. Employers are being required to do things on a very short turnaround with very little guidance, and things could be thrown out immediately. So the December 6th deadline that I gave you before, this is back to the ETS because it's the one that I could see coming and hitting most of you. That deadline has been effectively set aside. That's today. This is when you were supposed to have your written policy. You're supposed to determine which people are vaccinated, which ones are not, obtaining proof, identifying what you're going to do with the non-compliant, provide support for vaccination, get the positives notified, alert OSHA within 24 hours, mandate face coverings for non-vaccinated, and provide your policy and the disciplinary action, federal crimes for lying about exposure, and so on. My recommendation to you, if you fall within the ETS with these deadlines, is this. I believe that you need to go ahead and continue your effort to do these bulleted items as soon as possible. I did have I'm gonna see if I can get it on the screen for you. I had a deadline or a sheet that I really liked from OSHA that told us the checklist of items that you should be doing, and I closed out of it, and I'll see if I can get it for you so you can see it. But that checklist, is this it? No, I'll try to find it after I get done here. The checklist is very good for how quickly you should try to get things done and why you should be trying to continue to get these things done, because the federal government is going to implement this at the drop of a hat if the Sixth Circuit sets aside the Fifth Circuit injunction. Are you prepared if the federal government comes out tomorrow, hypothetically, let's say that the Sixth Circuit on Friday says Fifth Circuit was completely outside of its authority, we hereby throw out the entire temporary injunction, and now you are allowed to go forward with, government's allowed to go forward with the emergency temporary standard. You have to ask yourself as a company, as an HR professional, are you ready if the government flips a switch on Friday? If the answer is not yes, then you need to do the legwork. What we've been suggesting everybody do is this. Prepare your written policy. Establish the appropriate procedures and make your announcement to your employees as to which policy you're going to follow. Those procedures are you going to have a hard rule? Everyone must be vaccinated, or a soft rule. You don't have to be vaccinated, but if you're not, you have to follow the following testing regimen. You have to report all of your results to the appropriate authorities, document everything, quarantining, and so on. That written policy should already be ready to go as soon as this is set aside. Personal note, I do not believe this will be set aside. I believe that the rulings will ultimately be that this is extreme overreach from the federal government. I've said that since January. I stand by that. There is no way you can do a nationwide one-size-fits-all mask mandate, vaccination mandate, and say we're going to do this through OSHA because we don't have any other way to do it, which is effectively what the president said during a speech in September. We can't get this through one way, but we're going to do it another way. We're going to use OSHA. Can't do that. And now we have that gets used, and it was quoted in Judge Van Tatenhove's order that the president made that statement in September with the decision to try to skip the limitations on federal government. You also have state-by-state measures that are shutting this down in Florida, in Texas, in Alabama. Kansas just signed it. You cannot preclude people from working. This is a nightmare for you all as HR professionals, and I don't have good answers for you. But I would get your policy in place. Have one ready to go. Do not implement it unless you want to voluntarily do what the federal government's suggesting in the mask mandate and vaccine mandate for the ETS and require your employees to go through it. The problem you're going to have is, I will tell you this, you have 3 weeks before the bill gets signed in Kentucky. In my humble opinion, starting in January, as soon as they're back in session, I guarantee you that the Kentucky House and Senate will adopt an anti-vaccine mandate that will punish employers for forcing employees to get vaccines. And I wonder, hypothetically, I'm wondering whether they'll make that retroactive. So here you might force somebody to get a vaccine, and the state law comes in and punishes employers for forcing people to get a vaccine. I don't know that that would be constitutional either. I don't know whether they can make it retroactive, but I guarantee you there are people ready to draft a new bill in the state of Kentucky starting January 3rd that will make this a mask-free, vaccine-free. That critically impacts hospitals. Hospitals are dealing with that in Florida right now. My recommendation to you is take a look at some of the big boys down in Florida that are dealing with this mask mandate, whether it's the ETS that was in place and Disney took action to not enforce it, or whether it's hospital and you look at some of the Florida State University, University of Florida, North Florida hospitals and so on. They have had to adopt new policies based upon the vaccine, anti-vaccine laws that were adopted by the governor down in Florida a month and a half ago. There are enough of these going on that I doubt that Kentucky will ever have a vaccine mandate, because we will fall in line with the Florida, Alabama, Texas, and Kansas line of government anti-vaccine requirements. We already have one on the books. It's the one that I pointed out to you a few weeks ago that raised challenge, at least to me, as to whether the nationwide mask mandate would ever take effect. It's being used by Attorney General Cameron to attack these, to point out that we can't have these laws in place. So, what do you do? If I were you, I would not implement it already, but I would prepare one. If you're going to have one and it's going to trigger based upon the United States government's activities, then make that announcement clear to your employees that you're waiting for direction. You're waiting for the federal government to issue a new policy or indicate its adoption of a new directive, and then have all of the footwork done beforehand. Create a policy and a process for dealing with the reasonable accommodation requests, because that's going to be a nightmare. We've addressed it in the past. The ground under which my previous recommendations to you were made has shifted. The federal government is taking a very slippery slope response, in my opinion, to this accommodation. They're basically saying accommodations don't matter. They must be real religious accommodations. They must be real disability accommodations, and you have the right to reject those employees. You also have the right to fire those employees if they don't follow through. I would be very careful about all of that. But you do need to set up what you're going to do once this gets adopted, because you're really going to have basically 30 days to get this done. And some of these fully vaccinated things will take you at least 14 days to get that person fully vaccinated. So have your policy, your process mapped out at minimum right now. Go to the OSHA website, pull down their COVID policies and create those for your company with your letterhead ready to go. But remember, you can't just adopt what OSHA recommends. You actually have to have the underpinning ready to go. You have to have the process built, because if Allison's your process and she's one person and you have 500 reasonable accommodation requests that come in, and she has to answer all of those at one time, literally that one day or that 1 week, can she handle that many at that time? And what documentation are you requiring? Is a screenshot enough, or a digital record? Do you have the form filled out or ready to go? Do you have an application form? Do they upload the documents? Who reviews it? Who reviews an appeal of a denial? All those things have to be determined. The maintenance of records of vaccines, you all already know how much of a headache it is to try to maintain medical records in a red file. You better start putting those vaccine records into a red file, and you better have them ready, because OSHA says they have the right to inspect those with or without cause. Quite frankly, I'm not sure that the inspection part of OSHA's directives has been set aside. So if they want to inspect your vaccine records, you should have those put together and ready to be inspected, even though the mandate itself is not in place. Red files, green files, I don't care what you want to call them, have them there with the proof of vaccine documentation. What proof are you going to accept? We did have slides on what proof was identified as appropriate under OSHA. Make sure you have a well-established policy as to what you will or will not accept. And also the process for the proof of testing. It's critical to remember that the employee cannot self-report, meaning they can't test themselves and report that to you. There were some really awesome questions the last time. What if their spouse, significant other, girlfriend, neighbor, best friend, what if they're the ones that did it? Well, the federal government failed to identify the bright line rule as to who could and who could not inspect. I suspect the next go around will be cleaner. You need to have a policy that tells your employees what they can and cannot do. Best thing is a third party. Don't put yourself in the position of approving or not approving. What if it had 2 lines and you only saw 1? Then are you liable because you didn't properly look at the stick that identified it? How are they going to handle the stick versus written? That got asked of the administration on Friday with the travel ban, which we're also not covering today. But the new travel ban says they must have written record of a negative test. And the question was, what do we do with the sticks? If you're not familiar with the sticks, they are basically pregnancy tests for vaccine. You're either pregnant or you're not. You're either vaccine, COVID positive. You're either 2 lines positive, 1 line not positive. The problem is that what if you as the employer improperly read that and then somebody comes into work and everybody gets exposed? I would not put yourself in the middle of verification. Require a third-party verification. Find that third party and sign an agreement with them, or at least have them on the hook to do it once this triggers and becomes law. Take all of the steps you need to do to be in compliance with this, the December 6th deadline. I would highly recommend that you get all of these bulleted items ready to go so that if and when the 6th Circuit, and I do not believe it'll be set aside. However, in the event it is, you need to have your policies ready to go, because what they're going to say, and they've already hinted at this, 1, we wanted you to voluntarily do this during the time period of the legal challenges. 2, We announced this back on November the 5th, so you've had plenty of time to put together the policy. And 3, an emergency temporary standard is effective immediately. So we expect them to come out and say, comply now, probably 2 weeks or 30 days max. So my recommendation, have all of these policies in place. Mary, I'm gonna get to your question here in just a second. I get it, and that's one of the issues here. So the last little nugget on here is that the Sixth Circuit is really gonna be front and center, because I suspect that Judge Van Tatenhove's ruling will end up being appealed to the Sixth Circuit today or tomorrow. That will put that front and center in the Sixth Circuit. The CMS will be front and center in a different circuit, or we might win the lottery, but we already know that ETS is going to be at the Sixth Circuit as well. All of these will probably be en banc from the Sixth Circuit, and it's going to be a mess. So,
Jim, there was one question I couldn't answer, or that I didn't feel comfortable answering. If you wouldn't mind going ahead and doing that from
yeah, I'm going to answer
Helm.
that one too.
Pardon?
I'm going to answer as many of these as we can, and I've got some that are direct messages to me, which sometimes it comes in. So I'll try to answer those as well. So the really cool one that came up is a private one to me. And the answer I'm going to tell you is, I have no clue. There you go. The question was, what if your corporate headquarters is in another state and they end up with a policy for everyone to be vaccinated? We have remote employees all over the U.S. I want to expand that a little bit, which is, what if your headquarters is in a different state and now you have a mandatory setting aside, I'm going to use the medical right now, mandatory setting aside of the medical CMS or the federal contractor. You now have a mandate in one state and not in the other. How are you going to handle that? The answer, number one, is very carefully. Number two, you need to have an attorney investigating all of these different state requirements, because every single state is coming up with their own pro or anti-vaccine mandates. This may well end up getting to and I'm going to answer one other thing. You must comply with the federal law in those states where the federal law applies. Sounds pretty rudimentary, but unless you're in the state of Tennessee, Kentucky, or Ohio, then you're a federal contractor, you must comply with the federal law. If you have employees in the states of Kentucky, Tennessee, and Ohio, you cannot enforce that policy as to Kentucky, Tennessee, and Ohio employees, but you must as to those employees that are not in Kentucky, Tennessee, and Ohio. Now you're seeing the nightmare for the clients I have that are everywhere, 41 states, one of my clients, and with employees in 41 states. Now you have to try to figure out, how do we comply with each one of those? The answer that you really need to be careful of is, you need to get guidance from an attorney that knows how to address the different policies in the different states. The other issue becomes, what do we do with those states that literally are punishing you for compliance with the federal government? Florida, Alabama, Kansas. Florida's law was built in such a way to make sure that if you complied with federal law, you're going to get a larger sanction for compliance with federal law than you're going to get for non-compliance. This gets into a really deep states' rights federal law issue. But remember, the federal government is supposed to be nothing but the safety net. They have taken on this huge role with COVID and before COVID, but definitely with COVID, of trying to be the overarching mandatory vaccine, mandatory everything. If the state says you cannot comply with it, like Florida, is literally dissolving its cooperation with OSHA. If Kentucky does that, OSHA will not apply, because Kentucky has its own and says you are not the authority in the state of Kentucky. Until the Supreme Court comes in and says, oh, yes, they are, the reality is if Kentucky adopts a statute and says we are not complying with OSHA, you will not comply with OSHA. So another question is, when do I expect them to accept natural immunity? I'm an attorney. I did stay at a Holiday Inn Express last night, but I am not a medical doctor. The shocking thing for me, if I can make this comment to everybody, is it is a known fact that exposure to an illness is much stronger defense than the vaccine immunity. Why they're not studying it, why they are not addressing natural immunity, why they're not going on genetic information instead of vaccine information, I don't know. I don't understand it. I could say political comments, and I'm not going to, as to why that is not being looked at. The reality is right now, and it's sad, you are evil if you're not vaccinated, and you are a hero if you're boosted. If you've only been vaccinated and you're not boosted, then you're almost in the unvaccinated category. The definition of vaccinated is about to change from what I'm reading on some things, where they may not allow you to travel without being vaccinated, including a booster. Last Friday, it was floated. This would have been on the webinar today because of how critical it is. It has not been adopted, but it's still being talked about, legitimately talked about, as to whether they will mandate a copy of your vaccination card in order to go on any public transportation, which includes taxis, Uber, Lyft, flights, buses, trains, everything. That is still being discussed as a potential, and the problem is, for those that don't believe that the federal government should have overreach, they do have overreach in the FAA, the Transportation Safety Administration. They do have the ability to institute federal protections, and so that will be the next battleground, but they are talking about potential mask mandate, expanded mask mandate to include proven vaccine. Then there is, the question I got asked is about New York. Yes, New York has a vaccine mandate. Yes, they actually have, you cannot go in public if you're 5 years old or older. If you have, unless you've been vaccinated. That includes your children. That includes everyone. You have to show proof of vaccine. If you have employees in New York City and also in Kentucky, you need to have different policies based upon local ordinances. You have to keep up with every state's laws right now, and that's what I spend a lot of my time doing, is watching these legislative bodies like Kansas on Friday signing it. We talked before about, I think Iowa signed one. The different states are having emergency sessions to adopt anti-vaccine laws. It's your job to start looking at those and maintaining your up-to-date. You can have a corporate-wide policy. My recommendation is to have a corporate-wide policy that meets the minimum of whatever state you have employees in. One of the issues that was, I'm going back to the federal contractor that Judge Van Tatenhove issued his opinion. Anybody wants to see it, I'm gonna put it on the screen real quick. This is the opinion and order. One of the things that he addressed in his opinion and order was the fact that it mandated all federal contractors to have 100% vaccination, including all remote employees, no matter where they are located. even if all they do is work from their home and they never interact with anyone, you must mandate vaccination. That creates a tremendous log jam between the vaccine rules that they're trying to implement and the Americans with Disabilities Act, FMLA, FMLEA, and also with religious exemption to the policies and procedures. My recommendation is a policy across the board with whatever, if you have somebody in Florida, this doesn't apply to you. If you have somebody in a state that has anti-vaccine mandate, anti-mask mandate, then you cannot have a policy mandating vaccines. But you can have one ready to trigger in those states, and you can do it one of two ways. If you all have seen your policies for credit cards, you'll notice on a credit card disclosure that you have one overarching policy if you read their big long thing. And that says, if you're in the state of New York, California, or Minnesota, the following applies to you. If you're in the state of Kentucky, so on and so forth, the following applies to you. You're going to have to nuance your policies in these states because it is impossible for us to keep this clean and to have one policy that goes across because everybody's adopting their own. It's one of the reasons why this is so critical to get the guidance from the Sixth Circuit and ultimately the United States Supreme Court.
Jim, we just got another good question too. It says we developed a vaccination policy and processes, ran it through our legal, and decided to implement it effective today. Are you saying that we cannot do this at this time?
Let me get to that one in a second. The question about vaccinated and the spread, how are these medically necessary? Mary asked that question. Now that vaccinated are spreading both the Delta and the Omicron, it is really, that's why I said it's really surprising to hear the evil connotation for people who are not vaccinated. That disappoints me. The reality is this can be spread by vaccinated. It has already. The Omicron came into the United States based upon vaccinated status. So I don't know why these are able to be considered medically necessary other than you have a federal government that has said that it is. Little tidbit. This is your Holiday Inn Express tidbit. I am not a medical doctor. Coronavirus has been around since the beginning of time, and the coronavirus is the common cold. The COVID-19 strain of the coronavirus is the one that came through and did such damage, but it is an upper respiratory illness that is very common, not COVID-19, but the coronavirus itself. So the problem is at some point, the different variations are going to have to be addressed differently based upon the impact that they have on people, not necessarily on the title that's on the illness itself. But the medically necessary is being imposed by the federal government, and we're required to follow it until Kentucky says OSHA no longer has authority in the state of Kentucky, which I suspect may be another thing that may come out in January. Yes, the quick question I have on a direct message: if an employee requests any religious exemption or any disability or any other exemption, and you're allowing them to work, which is a decision you can make, you can require them to be tested weekly, twice a week, 3 times a week, or daily, and it's at their cost. You also have the ability to actually terminate them. I would not recommend you do that simply because of the issues, and I don't ever want an employer to be the first one sued. But yes, you can require them at their own cost to be tested weekly or more frequently. However, make darn sure, well, not darn sure, you can require them to pay the cost as long as it does not drop that employee below minimum wage. Also, if you're requiring them to pay the cost, I'd have it go through a third party where you never touch any of the testing results, or the cost associated with it, because if you're trying to deduct it from their wages, you have to comply with every state's wage deduction laws. And reminder to you, beware of the state of Indiana. As I've told you many times with wage deductions, you have to make darn sure you're in compliance. Mary, you had a vaccine policy you did that you ran through legal, decided to implement it effective today. It depends on the specific type of company you're in. If you are in the medical field at all and you're subject to the CMS, the answer is no, you cannot implement it today, because there is a temporary injunction in place prohibiting enforcement of that policy. However, if you voluntarily, even if you're under the CMS, and you voluntarily adopt a standard that does not reference the CMS, yes, you can adopt that. The problem is, it's a very small chance. But the Kentucky legislature is going to meet in 3 weeks. When the Kentucky legislature meets, and if they declare that mask mandates and vaccine mandates are banned, could they try to make that retroactive? Possibly. So my suggestion is, I would not fire people for non-compliance. I would try to find a reasonable accommodation for non-compliance, because if you fire people and by some chance the state comes in and says, we make an individual's rights retroactive, and if they got fired for refusing to take a vaccine, they have the right to sue you. I don't want you on the wrong side of that. Also, keep in mind, it was a very broadly worded anti-vaccine statute in the state of Kentucky that was adopted last year. It is not employment related. It is not, because nobody back then even thought the federal government would do an OSHA across the board vaccine mandate. However, there is one that says that you cannot take adverse action against an employee in the state of Kentucky for properly documenting in the alternative to a vaccine mandate. So you need to pull that out, take a look at that, because you have to build that into whatever policy you have. My recommendation is to make darn sure that your legal has a full understanding of all of the laws of the state of Kentucky and anywhere else where you have employees located, whether they're remote or not. And adopting a policy as of today, when we don't know what the federal government policy is, and you no longer have the ability to say, we're doing this based upon OSHA. Well, OSHA said, you don't have to do this right now because we're in litigation. We think we're going to win, but we're not going to enforce it. So you can't just say we're doing this because of OSHA. You have to have your own underpinning for your own law. So make sure your legal team is looking at this the right way, investigating all of the underlying impact and all building into the exception for the policy, the Kentucky law that says that you can't take adverse action based upon that. I've got a private one here that's kind of long that talks about the policy being adopted with a statement that they must show proof by the end of December. It's going on, just a second. Oh, this is a long one. So basically it's saying, can the employer still fire people for not complying with a voluntary mask mandate and voluntary vaccine mandate? Focus on the vaccine, not on the mask, because everyone's still wearing masks indoors. So the answer is, unfortunately, yes. EEOC has said that if you cannot reasonably accommodate, you can fire people. My suggestion is that the employer be very careful with that. It looks to me like that policy was adopted with the understanding that OSHA was going to take effect on January the 4th. So it was requiring full vaccine, proof of vaccine, documentation, and so on in time for enforcement of the January 4th deadline. I would highly suggest that the employer be very careful to investigate everything and make sure that you're not simply relying on the outdated OSHA ETS, because it is not the law right now. You can voluntarily comply with it, but you darn well better make sure you built into it all of the protections that Kentucky has in place for people who document their conscious objector to the vaccine and so on. Meredith's question is a good one. Your policy is wherever their situs of work is located. The problem with that is, what if they work remotely from their home? What if they travel and they're temporarily in New York City? Hypothetically speaking, I had a meeting, I canceled it. It was last Thursday, Friday, Saturday in New York City. Because that was our meeting location, we were all required to comply with what New York required of all employers bringing people in to meet in their city. So the answer is, where you require, and it's an old term, but it's where the employer requires the employee to suffer employment. Yep, that's the right term. Because they are doing your will and not their own. This goes back to, if you require them to stand in line to be screened before they get to work, you're supposed to pay them for the time that they were being screened. Why? Because they're doing that at your direction, even though it was a federal mandate. The only exception is this ongoing testing for the unvaccinated, which I believe is going to be challenged next as a discriminatory based upon vaccine status, which is precluded under our laws. But you don't have to pay them to go get tested, even though that is part of your requirement for them to continue working. That's the only exception. If you require them to cross state lines to work, you must comply with both states. So hypothetically, if you have somebody that works, I had a client who did in-home health care, and their people would be certified and licensed in both Indiana and Kentucky, and they'd go across the border, Ohio and Kentucky, and they'd be across the border. That person has to comply with both. What do you do if that person has to comply, hypothetically, in Indiana, but cannot do this in the state of Kentucky? Excellent question. That's why this is such a nightmare for HR. You need legal guidance specifically on that individual, and I'm not sure how to give that to you. So, there's a private message. I agree with you. I can't say that on the air. Okay, yeah, Mary, on the nonprofit side, as long as you are trying to document and not fire people for non-compliance, come up with ways for them to be able to have alternate work arrangements and so on. That's the best way to go. I would be careful about treating newly hired differently than people who are pre-existing, because then you could get sued for discriminating because not all of your employees are being treated equally based upon vaccine status. So be careful about that. I understand the policy behind it. Just be careful. Can I restate for Kentucky? You have to be very careful about non-compliance with COVID, because Kentucky adopted, and I'll see if I can get it on the screen. I talked about it last week. It became law last March over the veto of the governor. Let me see if I get the actual rule on the screen. Final. All right, so this is the law of the state of Kentucky. Sorry about all the red line, but this is the way the law was actually adopted. Here, the immunization of any emancipated minor or adult who is opposed to medical immunization against disease and who objects by a written sworn statement to the immunization based upon religious grounds. Then it also has, in the event of an epidemic, the cabinet may require the immunization of all persons within the area of the epidemic against the disease responsible for such epidemic, except that any administrative regulation promulgated pursuant to this chapter, administrative order issued by the cabinet, or executive order requiring such immunization shall not include the immunization of a child or adult for whom, in the written opinion of his or her attending medical health care provider, such testing or immunization would be injurious to his or her health, and the immunization of any child whose parents or guardians are opposed to medical immunization against disease and who object by a written sworn statement based on religious or conscientiously held beliefs, or the immunization of an emancipated minor or an adult who is opposed to medical immunization against disease and who objects by a written sworn statement to the immunization based upon religious grounds or conscientiously held beliefs. So that's the problem here. This is not directed toward employers yet, but I can see this having whiplash law coming back on you. So my suggestion is kid gloves in the state of Kentucky based upon the potential issues that you might run into. The removal of OSHA terminology was the best way to go, Mary, in response to that, because if it's your own policy, that's the best thing. Just make darn sure you're trying not to go overboard with conscientious objectors, because I can see this becoming part of Kentucky's anti-discrimination laws. Like I said, I do not believe it will be retroactive, but I can't swear to it, so I'm trying to be overly cautious in giving you all guidance. All right, Tyler, Allison, what did I miss? How many mistakes did I make? And how many people out in the audience are ready to strangle me?
Well, I can't speak to the last two, but I think you hit all the all the questions.
Did I? All right. So the update today is a stay tuned, be prepared, don't go overboard. Beginning in January, I suspect, last January, you all will remember we had the Kentucky updates because those rules were coming fast and furious. I think that Kentucky is going to very quickly follow the Florida OSHA, anti-OSHA policies. It will be vetoed by the governor. It will become law sometime in early March. I'm just predicting. Be prepared. I wish I had more definitive